All right.
So, hello everybody. I see some familiar names and some not so familiar names. So I appreciate everybody coming. I want to thank everybody from our Green West Orange for giving me this opportunity to try to bring people more up to date with what's going on with redevelopment. I have a rather lengthy presentation, so Sally or Lauren, you can just cut me off when you feel it appropriate. But I thought because there are some more recent visitors or residents in town, that maybe I'd err on this a little bit on the side of the historical side for additional context for current events that are going on right now. I broke this up into five sections. What is redevelopment and why does it matter to you? A not so quick timeline of how we got here, including many lowlights, an update on recent events in downtown redevelopment phase two, the recent lawsuit that a lot of people know about, and some potential next steps for us. So, what is redevelopment and why does it matter to you? So, the state law was designed to reinvigorate blighted areas of the state that can't attract private capital investment without municipal help. Theoretically, it encourages private investment both directly and secondarily. So what it essentially does is allow an overlay zoning that can, it's a fancy name for it, can just be different from the zoning that applies to the rest of the municipality, and allows the municipality's governing body to specify what can and can't be in the zone. So it also gives you tools to accomplish your goals. One of them is it allows for eminent domain, which is taking without an owner's consent, taking the property. It also gives exclusive right to develop within the redevelopment area to one company, and it allows, it doesn't require competition. So redevelopment also opens the door to 30-year property tax abatements. Just means basically the beneficiaries don't pay property taxes for up to 30 years, and payments in lieu of taxes instead that typically take 3 decades to gradually and finally get even with what the property taxes should have been. So for 30 years, for the most part, you're paying, if you're the redeveloper, you're paying less property taxes than you otherwise would. So theoretically, the pilots serve as an incentive. The discount to what would otherwise be your regular property taxes applies only to the value added by the redevelopment project. By that, I mean the redeveloper still pays property taxes on what was already there, what already existed, although that amount is usually discounted significantly as well. So when you go into redevelopment, you actually will take a cut in the revenue that the property produces. So it also allows for what's known as redevelopment area bonds, or RABs, which provide lower interest funds for a redeveloper that are repaid by the pilot revenue that would otherwise go to the municipality. So they're called RABs, but I call them ROBs because these the money from the borrowing goes to the redeveloper for the project at a lower interest rate than they could qualify for. And when they pay the money back for the bonds, they pay it back to the bondholders and not to the municipality. If you weren't paying the bonds, you could just pay the money back to the municipality. So, in addition, no part of a pilot goes to the school district, but taxpayers make up that loss of revenue through higher property taxes. In other words, even though the project does not increase the revenue going to the school district still gets increasing costs, and those increasing costs are paid by property taxers, property taxpayers like you and me. So the pilot discount can amount to millions of dollars in foregone future property tax revenues in most commercial projects. But why does it matter? Well, redevelopment can give a lot more control to a municipality to change or reinvigorate an area, investing capital and attracting others with capital. but it may give perhaps too much control to the municipality, particularly with a majority of the governing body closely allied with the mayor. Redevelopment can sacrifice significant future property tax revenue that must be made up by taxpayers. Because here's the bottom line. Taxpayers fund redevelopment through higher property taxes for roughly 3 decades until the redevelopment project matures and pays its full share of property taxes. So here's a timeline. This goes back to 2003, well before I was on the council. But in 2003, the town council approved the original downtown redevelopment plan. And this is the guidelines for what can and cannot happen within the redevelopment area. 2006, 3 years later, the town council approved the downtown redevelopment agreement with PRISM. 5 years later.
Joe,
yes.
Do you have a presentation that needs to be shared?
I can do that, but I simply couldn't get all of this material together and put it in a presentation at the same time.
All right.
But I can certainly make it available if you think it'd be helpful to people.
Okay.
So in 2011, Wells Fargo began foreclosure proceedings against PRISM for defaulting on the mortgage at 55 Lakeside Avenue, which is also known as the Barton Press property. This is in 2011. PRISM was already getting in financial trouble. In April of the next year, 2012, residents began a petition effort for a referendum on the proposed $6.3 million in general obligation bonds for the project. This is phase 1. And I think perhaps some of the participants, those petitioners, are actually on this call today. This is back in 2012. The town would not certify the results of the petitions, and so residents filed suit the next month. In October of 2012, I began asking about the foreclosure against PRISM on the Barton Press property at 55 Lakeside. The next month, the town sent the first 2 notices of default to PRISM for failure to pay into an escrow account and failure to pay more than $135,000 in delinquent property taxes. Now, under the redevelopment agreement, failure to pay property taxes and being delinquent is an event of default, which, if not cured, could lead to defaulting out the redeveloper and the loss of everything that they have in a redevelopment. PRISM cured those defaults with payments. In January 2013, PRISM was the only bidder for 55 Lakeside in the foreclosure proceeding and actually acquired clear title to the property with a payment that reportedly saved PRISM millions of dollars. The same month, PRISM issued a press release, quote, "With site approval in place, PRISM set to launch Edison Village," end quote. And I just bring that up in January 2013 because this was while the petitioner litigation was going on and PRISM was indicating it was ready to move forward. So when you hear, oh, the litigation slowed down things and they couldn't do anything, it's bogus. PRISM publicly put out a news release that said they were ready to start working. So that was in January 2013. By November of 2013, the lender for PRISM at the property at 217 Main Street, that's the one where the CVS is, and all of the trucks and cars parked out in the parking lot, began another separate foreclosure proceeding. By February 2015, it became eminently clear that PRISM could not secure the financing to begin construction, and the mayor announced a new set of phase 1 investors from Dune Realty, and a new entity, DGP Urban Renewal, got permission from the council to take over the project. This was in February 2015. In September of that year, mayor sent a third notice of default for failure to pay delinquent taxes or to start construction as required. I thought it was significant to tell you about this third one because the mayor didn't even bother to tell the council about it. December of 2015, the New Jersey Supreme Court ruled against the final issue that was existing in the appeal by the petitioners, and basically ended the lawsuit. This was in December 2015. In February of 2016, for the first time in 4 years, in 16 quarters, PRISM paid its property taxes on time. The next month, March, DGP said it secured a $70 million construction loan and began construction. Later that year, PRISM again became delinquent on property taxes, but was not served with a notice of default. In November 2016, PRISM lost 217 Main Street, the 217 Main Street property in the foreclosure auction, owing about $3.7 million. Again, it had not paid taxes or their mortgage for years. In September of 2017, the council majority approved Downtown Redevelopment Phase 2 redevelopment agreement, and that's where we're headed. So the third section is about Phase 2, and it was from that announcement in 2015, it was virtually missing in action until earlier this year, despite an aggressive and detailed timeline of progress. It was the calm before the storm. Because PRISM had such problems with Phase 1, the redevelopment agreement for Phase 2 was very detailed. Timeline said, you've got to do this time, got to do this. It was very detailed. And all along, they weren't meeting the timeline. And every time I asked about it at council meetings, we were told they're working on it, they're working on it. What actually happened, you'll see later on in the presentation, is that PRISM was defaulting out the wazoo on all kinds of things that it should have been doing, but it wasn't. So earlier this year, a couple months ago, the first indication that something may be wrong was the presentation of the draft fourth amended plan for downtown redevelopment. Now, what that means is that every time you make changes into what you think the zoning should be in a redevelopment area, you've got to have a new amended plan. So this was the fifth version of the downtown redevelopment plan, which shows you a lot of the challenges that the project has faced. So for those of you who haven't seen the draft amended plan, I won't say it's filled with typos. There are several typos there that suggest that it was hurriedly drafted. And the major change in that was the creation of a new zone for a movie studio. And what's amazing when you go through it is that there are basically no specifics to this major addition to the project. Here's all it says, quote, film and video production campus. One or more parcels utilized for the creation of motion pictures, television shows, and other video content and visual media. Multiple uses should be permitted on such a campus, including stages, rehearsal spaces, offices, workshops, storage, food service, and other uses related or incidental to facilitation of the primary use of the facility. So if you're getting ready to put together a studio, it would seem logical to me and perhaps to you that you have some specificity about what you intend to do. Is it going to be one building? Is it going to be multiple buildings? What are the buildings going to do? Are they going to be soundproof? What's going to happen to the roads around it? But there's none of that in here, or virtually nothing like that in here. But they're allowing a huge height zoning for the facility. It can be as high as 6 stories or 75 feet tall. The standards in the standards in regular zoning throughout the rest of the town are much lower for these type of buildings. The draft plan calls for 60 units, residential units per acre, with buildings of a maximum of 6 stories, 75 feet in height. What we're basically talking about here is those of you who are familiar with Crown View Manor, up off of Eagle Rock, just before you, a little bit east of the intersection with Gregory Avenue. Those are about 6 stories and 75 feet in height. Quite a bit of density and height. And I'll be posting the planning board minutes of the planning board's consideration of this fourth plan tomorrow, and nobody at all asked about the density. Now, those of you who are familiar with traffic along Main Street and some of the nearby roads during both morning and evening rush, you know that sometimes the traffic on Main Street can slow down, stop for as long as 2 hours, even more during that. And so just imagine what the traffic's going to look like if there's 60 dwelling units per acre in this new project. The draft plan calls for 44 affordable housing units. There's a potential problem with that, in that under state law, the township incurred this affordable housing obligation in phase one, when they built the 330 apartments and the little less than 20,000 square feet of retail space in phase one. And the council majority, but not me, approved a redevelopment agreement, pushed back to phase two the obligation to fulfill that affordable housing requirement. But perhaps some of you are already saying to yourself, well, with PRISM defaulted, who fulfills that obligation? It's a good question, because the replacement developer will have its own affordable housing obligation. According to the draft plan, 20% of any market rate units will be required to be set aside for affordable housing. And if that's true, then why would the replacement redeveloper want to take on this additional obligation to pay somebody else's affordable housing obligation? That may explain the 60 unit density, since that would give a new redeveloper a lot more in gross profit that will allow them to build these affordable housing units. But we just don't know, because this is one of the many questions that have just gone unanswered. Meanwhile, if that's actually the case, then it looks like PRISM is getting off scot-free from what is certainly a multi-million-dollar liability for affordable housing that it took on in phase one and was obligated for on phase two until it was defaulted out. So one of the other interesting terms in the plan is that it allows the town to basically, they use the phrase vacate one or more streets, the redevelopment zone for the film production campus. That means streets that are now taking cars and providing curbing could literally disappear depending on how big this campus is. Which is probably not going to help traffic flow downtown. One of the other interesting points, there's another zone called Edison Mixed Residential. Back in 2010, when the original redevelopment plan was modified, it originally allowed for 17 dwelling units per acre. In the fourth plan, as I mentioned, it's now 60 dwelling units per acre. So there's been a huge increase in the density that's allowed. Moving on, another recent event was the lawsuit that PRISM filed. Unbeknownst to residents, the mayor began the default process, getting rid of PRISM a few months ago. After being defaulted out as redeveloper, PRISM filed a lawsuit July 22nd. And it literally opened a Pandora's box of transparency on what's been going on, since most of what was alleged was unknown by residents and maybe even council members. Throughout these lawsuits, there were charges of conspiracy, fraud, widespread dishonesty. PRISM called the mayor and other defendants, quote, deceitful and duplicitous, end quote. It said it brought this action, quote, to prevent the opportunistic and nefarious scheme by the defendants, it said in the suit. And the township wasn't sitting by quietly. One of their defenses in their responses to the lawsuit was accusing PRISM of having, quote, unclean hands, end quote. PRISM accused the mayor of trying to take advantage of rising real estate prices and values to acquire PRISM's property and resell on more favorable terms. PRISM alleged that even before sending out the township's first notice of default, the township had solicited bids from other developers to replace PRISM. which is just mind-boggling. PRISM also accused the mayor of interrupting PRISM's attempt to sell property within the redevelopment area to two business entities that it was negotiating with. One was called Whoopi Incorporated, which is named after Whoopi Goldberg, who's a resident, and also MBS Holdings, which is a related entity. So as part of its allegation that it was doing what it was supposed to, PRISM said it had spent a little more than $13.4 million to acquire various properties within the redevelopment area. And that's sort of an important number because it comes back a little bit further in talk of settlement. The mayor allegedly told PRISM in an email exchange to change the direction of the project, apparently without going through the council, which the council is the governing body and it alone has legal authority to change a redevelopment plan or redevelopment agreement. Again, this stuff is just mind-boggling if it's true. PRISM also alleged that there was a resident here in town, John Wayman Henry III. PRISM said that he had been appointed by the mayor earlier this year as chair of the West Orange Economic Development Commission, allegedly at the same time that he was negotiating on behalf of Whoopi and MBS to purchase property in the redevelopment area to develop the studio facility. And PRISM alleged that this was a conflict of interest that was not disclosed to it. PRISM alleged a violation of the confidentiality of an existing non-disclosure agreement that parties signed when the negotiations for the studio property began. Quote, on approximately March 23rd, 2021, a representative of the commission circulated a presentation deck titled Black Mariah Studios P2. The Black Mariah Studios P2 deck essentially copied and pasted pages from PRISM's Phase 2 presentation deck. This outrageous misappropriation of PRISM's work product is just another web in the township defendants and Mr. Wayman's greater scheme to cut PRISM out of the redevelopment plan. So in the lawsuit, again, it's just an allegation, but it seems pretty credible. It seems like something that you would want to necessarily track down. Because Mr. Henry is described in the litigation as representing Whoopi and MBS on the other side of the negotiating table from the town designated redeveloper. But now the mayor is asking the town to pay for Mr. Henry's legal defense. There's a resolution on the agenda for tomorrow night, Resolution 231-21, that authorizes the town to pay $175 per hour to a lawyer to represent Mr. Henry. Other allegations by PRISM included that the town manufactured events of default. And then on the other side, the town accused PRISM of breach of contract, citing a failure to timely make infrastructure improvements and build the 44 units of affordable housing, among other defaults, including not following the process for claiming a force majeure provision within the contract, citing the pandemic. One of the things the town alleged was that PRISM changed the project ownership without notifying the town, which is just absolutely prohibited. And let me keep in mind, because transparency is pretty big to me, is that the town didn't disclose this litigation to the public until 3 weeks later at the August 17th council meeting, and even then didn't provide any details. And then after that was announced, after Council President Matu Brown said at the meeting that the council would not respond to resident questions or discuss downtown redevelopment at the public meeting, she posted a statement on Facebook and commented with residents on the Facebook. And the mayor did the same thing. So it was basically a ban on talking about it because of the litigation, except when they wanted to. And then last week, the litigation was halted by a settlement. I'll get to that in a little bit later. I'm getting towards the end of my presentation, so if anybody's still awake, I appreciate it. What are some of the many next steps from where we are now? And I think in this context, it's pretty clear that residents and the council should insist on requiring more transparency and less speediness on the legislation related to redevelopment. Here's some of the other steps they've got to do. At some point, since we've gotten rid of the redeveloper, we've got to start the process of finding a new redeveloper. I am of the opinion that we should do a competitive search. We should ask all kinds of potential redevelopers to come in and present on what they think should be done down there, and pick from among them those proposals, what we think fits best with what we want. That hasn't been done since before the turn of the century, when we actually had a competitive bid process, a competitive proposal process for phase one, for downtown redevelopment phase one. Since then, we've had like 5 different redevelopment projects. None of them have been competitively proposed. Another crucial element is that the mayor wants to borrow $13 million to buy properties in phase 2 redevelopment agreement. It's not clear yet if we have appraisals yet that would justify purchases of those property. And it's not clear it's even allowed. If you go back to the very first redevelopment agreement, the original, not the redevelopment agreement, the redevelopment plan, this is what it says, quote, "At this time, it is anticipated that any property to be acquired within the redevelopment area will be purchased and assembled by private development interests. However, if acquisition in this manner proves to be unsuccessful, municipal acquisition by eminent domain will be pursued in order to create property planned and developable parcels of land." So in other words, there is no contemplation in any of the governing documents that the town buy property from the redeveloper. Because look at it from the redeveloper's point of view. They had exclusive rights to build within the redevelopment. But once they lose that exclusive right, they can't build on their property anymore. They basically have 2 options. They can either continue to own the property and pay pretty steep property taxes, or they can sell it to whoever the newly designated redeveloper is. There's just simply no reason, and there's no provision through any of the governing documents that I could find that has changed that provision. And on the other side of the coin, there's no provision in the governing documents that requires us to buy these properties. Because by buying these properties, we put ourselves at additional cost because we have to borrow the money and pay the interest, and pay the money back, and further risk to the ups and downs of commercial real estate. Who knows if this is the peak of the market? And who knows, given that this redevelopment has taken 18 years just to get to this point, how long we might have to hold that property. And if you look at the value of the property, it could be that we're giving up more than $500,000 a year in property tax revenue once the town buys these properties. It just makes no sense. So if the council approves the $13 million borrowing, other pending borrowing requests, including another $4.75 million for the Crestmont open space purchase, which I support, I think it's vital that we do that. That would mean our authorized and issued debt, just in less than the last 3 years, would have increased almost $55 million, or nearly 70%, 70%, to nearly $135 million. And I think before we do anything, borrow any more, we should see a detailed plan from the council and the administration about how they expect to pay all this money back. Now, late last night, some of you may know that the mayor issued a statement on the settlement with PRISM. And just want to, again, put that into a transparency context. That settlement was not announced by the town until Sunday night by the mayor. Although I found and published the judge's order from Thursday, citing a settlement without any details of what the settlement was. And the mayor, I asked him the question on his Facebook post, but he didn't explain why it took so long to publicly disclose settlement terms. And what was posted to the mayor's Facebook page apparently was not the settlement document referenced as presented in court by the judge, but through text in a Facebook post, which I thought that was strange. If there's a settlement agreement and the judge sees it and says it was in the court, why don't we see the actual document instead of of copy on a Facebook post. So here are some of the things he didn't talk about in his settlement. The township-owned public works property has been listed as one of the 2 town-owned properties intended to be purchased with proceeds from the requested $13 million bond order. That's on for second and final reading at Tuesday's council meeting. But why would the public works property and the other township-owned property be on the list since they're already owned by the township? And just as an aside, interestingly, the Barton Press property at 55 Lakeside, which we referenced the PRISM initially started to lose in foreclosure, but then bought it out of foreclosure, it carries an $11 million assessment on the tax rolls. So in other words, the assessment is supposed to reflect market value. And that's why we're doing the appraisals now for all of these properties in the redevelopment area. But according to the state database, this property alone is worth $11 million. And he's talking about settlement of $12.5 million. So one of the other things he didn't talk about was the affordable housing obligation, although that's a multi-million-dollar obligation that PRISM agreed to take up. But it doesn't look like it's reflected in the settlement. He didn't even bother to say whether elected officials would resume handling resident questions and discussing issues on downtown redevelopment at council meetings. I think that's really crucial that we as residents who are going to be shouldering all of these costs need to understand what we're getting ourselves into and provide some informed input to the council. He also doesn't explain why the closing of the settlement may not happen until the end of the year. And this is at the same time he's pushing forward as hard as possible to get a lot of this other stuff done, even though the settlement may take another 5 or 6 months. So there's lots and lots of pending issues, which when combined with the long-term lack of transparency over the years, may leave us in the dark unless we push the mayor and council members to provide more transparency. And we have an opportunity tomorrow night to attend the Zoom council meeting and public comment. You get 5 minutes. You generally starts no sooner than 7 p.m. Sometimes it's a little bit later, but you could get on there and express yourself if you want to. And I think this is a really crucial time to do this because of all of the embarrassing allegations that have come out recently on all of them. So I apologize for the length of the talk and would be happy to try to answer any questions.
All right, if we look, Joe, if you pull, Joe first, thank you very much. There's a lot of information to digest. And yeah, to see it would be cool, like in a timeline. It's like we have to create our own, but it's moving so fast. If you look at the chat, Joe, there's some questions.
Okay.
I have a question.
Yes, Sal.
Hey, Joe, in those settlement documents, it says the settlement amount is $12 million. Is that in addition to the 13 million?
No,
because the lawsuit was for 50 million against us.
Yes, the lawsuit itself PRISM alleged damages of more than $50 million in both compensatory and punitive damages. And price, they appear to be settling for a lot less. What may be confusing is that we seem to have put the cart ahead of the horse when it comes to this borrowing. And for some reason, the mayor began proposing that we borrow the money to buy the properties in the redevelopment area without any sort of legal necessity of doing it. And apparently, even before the settlement amount was negotiated. I just want to say one more thing. If this doesn't make sense to you, then join the club. Here is a company, PRISM, that has been defaulting, events of default, dozens and dozens of times over the process that we've had them. And for some reason, the mayor and council majority have agreed to keep them on. But Now that we finally defaulted them, why in the world are we proposing to borrow money that's got to be paid back, potentially by taxpayers, if this doesn't work out, to a company that we've defaulted out for failing to meet the requirements of the contract for 15 years? Does it make any sense to anybody?
Well, Joe, don't you think that the lawsuit was done to give the township, what's the word I want to say? The opportunity, the okay to settle with them, to give them this money by suing the town. Then the town says, well, we have to settle this. So let's give them the $13 million.
Yeah, perhaps so. The town looks like, just as, if you go back to 2018, when the council majority approved the redevelopment agreement, nobody on the council besides me was having any problem over the last 3 years with the lack of progress. And that includes the administration and the mayor. Why all of a sudden are we doing this willy-nilly and to the point of putting the cart before the horse? I don't know why. I've heard the, I won't call them conspiracy theories, but I've heard people say that the lawsuit was a setup for the settlement. But I also recognize that lawyers are under oath not to do something like that. They are not allowed to file false litigation. They have to certify that all of their allegations on their information and belief, they believe that those are the facts. So I know I hear that and I see where some of the facts fit in, but I would hope that has not taken place. But to get back to Sally, originally the mayor wanted to borrow $13 million to buy these properties, and then came back with a proposed settlement of $12.5 million. So it sort of sounds good. We're not having to pay nearly quite as much as we thought we were going to. So again.
Yeah, but Joe, if you look at the settlement, or look at what Parisi posted, there's $100,000 to get them out of something, and when you add it all up, as usual, in negotiations, if something could go on the benefit of the public or the developer, it always seems to land on the developer side. So I think when you look through Parisi's summary of the settlement, it looks like between the 12.5 million and a whole bunch of other money, it's probably up to about 13 million.
Well, I know better than to try to argue with you in real time. I'll just say, I'll admit that that some of these facts fit in with that theory. I just can't say either way.
Any other?
Will I go to the chat?
Yeah. There's nothing else in the chat.
Oh.
RM.
I mean,
I'm
I
sorry.
guess,
Yeah.
Yeah, I just wanted to point out when Joe was talking about this strange approach of the town buying the properties from PRISM, and then at some point selling them to a developer. When this process all started back in the early 2000s, there was another property. The building was owned, the old battery factory was owned by another property owner. And I think that owner was one of the developers who provided a proposal, but they did not get it. They did not win, and PRISM won. And so then the property owner had to sell his building to PRISM. And at the time, this is why PRISM, Gene Diaz talks about how much money PRISM has put into this project. Because at that time, if you remember, 2006 was like the height of the market. And because PRISM had to buy this property because they didn't own it from the property owner, they paid top dollar. And so that seemed to, and then the market crashed, and that seemed to enter into a lot of the reason why they couldn't get financing to go forward. But the fact of the matter is, when this all started, somebody, you know, the designated redeveloper had to purchase the property from the original property owner. So this is totally ridiculous that the town should get in the middle of this. You know, as somebody has pointed out on Facebook, once the town purchases this property, it, just like at Rock Spring Country Club, it goes off the tax rolls. So on top of us paying for the interest on the bonding, we lose that tax revenue until the town decides to sell it to the next developer. And who knows what the market's going to be like then. That's what happened to PRISM back in the early 2000s. And as the poster on Facebook pointed out, you know, it puts the township at risk. We're taking on the risk to purchase it. And of course, we're probably purchasing it for more than it's really worth. I mean, come on, we purchased Rock Spring Country Club, which is a lot bigger piece of property in a much nicer part of town for $12 million. And now they're telling us that the Barton Press property is worth 11. It sort of pushes the boundaries of believability.
Leanna?
Yes, thank you for the very interesting and informative history, Joe. Thank you. So I really enjoy listening and trying to understand it. My question is, what is our
I think,
official-
Leanna, you have some feedback. Do you have two devices? on?
Sorry, is this better?
Yes.
Okay, sorry. So I was saying thank you to Joe and the group for this and very interesting information. My question is, what does this group have an official position? Is there something that I can help to advocate? I don't really understand what the purpose of understanding all this information is. What is our official position as a group? And what are we trying to do? Is there a petition to sign or?
Sally or Joe, you want to take that? Or Kevin, too. Joyce or Sally, did you hear the question? All right, so I guess I'll answer, Leanna. I don't think we have an official position on this. What I can say is that our Green West Orange was founded on, you know, some of our core principles are, of course, the environment and how that impacts also how, not just the environment, how it impacts taxpayers and us in our wallets. So we've always been interested as a group and an organization in taxes and the affordability of West Orange. So in that sense, when the township starts entering into agreements, and in this case, settling a lawsuit and not being as transparent as I think they should, then we as a group and membership are concerned. So without a political point to it, it's really like what's happening downtown and how is that going to impact us, and including the development of the property itself. You know, I think Joyce had mentioned in the chat, has there been an environmental impact study done already? Like, how does that impact the township? And Joe had mentioned the traffic, how they may be a change up with the new plans. So all this goes into play with regard to the local environment, the school taxes also, and how it's going to impact the traffic, the noise, what it's going to look like. There's so many aspects to this. If anyone else wants to add to that, because you're all members of this. It's not just a group of us that are running it. We're all here and we're all residents. Joe, yes.
Just to briefly answer Joyce's question, there are multiple properties within the redevelopment area who have environmental contamination and various stages of remediation going on, including the town's public works property.
Okay.
The 217 Main Street property where CVS is, that has environmental problems. And I'm not exactly sure whether the Barton Press property still has contamination problems. It's referenced throughout the foreclosure documents and the property transfer and mortgage document.
Joe, who would be responsible for the cleanup if the township owns the property?
Well, the owners of the property are liable, but then you can get into a situation where you try to find the owner who owned it at the time of the contamination. But if you can't do that, if in many cases the owners are gone, it's the current owner, depending on how the liability is passed around in the various legal agreements. Like there is part of the redevelopment agreement does specify what the relationship is between the town and the redeveloper of what goes on at the Public Works Department, because that's always been Public Works property. That's always been for many years proposed to be sold as part of the redevelopment. And in fact, it's a bit crazy that we're talking about Public Works Department, and also there's a separate piece of property where the animal control building is, the facility is, because we have to have new places for those two facilities somewhere in the town to replace the ones that we're in the process of selling here.
Can I go up to Shilpa real quick? Hi, Shilpa.
Hi, everybody. Yeah, I hadn't heard about all of this, so it was interesting to hear your whole explanation and timeline. And also that retail space is still empty for so many years in whatever has already been constructed and redeveloped. And I initially thought it would be cool to have a film studio, like Montclair has so many studios, but not in a shady, backhanded way. Like it should be planned properly. And there are a lot of people I meet when I'm walking my dog who work in the film industry and go to Tyler Perry Studios or whatever. So it'd be a interesting project, a great project to have in town if it was done properly, considering all this traffic and everything. But also there's also so much redevelopment on Northfield, and almost everything that gets sold is now getting turned into condos. So I've heard other neighbors complaining about that too, like some of the restaurants. Like just everything seems like it's getting overdeveloped now. And I don't know if that's also tied into these same developers, or there are many deals going on around town.
That's a good point, Shilpa. It reminds me of a letter to the editor that appeared in the Chronicle perhaps last year. A town resident, Elizabeth Redwine, had written that, many of us moved to West Orange because we were trying to escape the city. There's a lot of transplants from Brooklyn, Manhattan, and elsewhere. We're getting here for the quiet. And now what's happening is it's turning into a city itself with all the development, minus a lot of the sidewalk that they should be including. But yeah, it's just a different feel now with the traffic especially. So good point. Yes, Joe.
Shilpa, thanks for your comment. Just to perhaps clarify, there's a very specific legal meaning for redevelopment when it's done as part of the state law. So there are no redevelopment projects along Northfield Avenue. You're absolutely right. If you think of redevelopment more generically, hey, you've got a property that did one thing, you want to redevelop it into another thing. That certainly seems like a redevelopment, but it's not necessarily done under the state redevelopment law. So all of that stuff along Northfield, that's clearly going to add significant traffic, is being done outside of the state redevelopment law. But you're also right that knock down the hotel and now putting up residential and childcare. And I think That's what they're thinking about doing at Essex House as well.
Okay, let me go to RM. Is that Rosary? Who's RM? They got their hand up. Going once.
Hey, it's
Hey.
me, Robin Miller.
Oh, Robin. I'm sorry, Robin. That's right. RM.
How are you?
Good.
Yeah, I just wanted to add, questions were asked about environmental impact studies and traffic studies. Unfortunately, they're not required until the development application goes before the planning board. So they're not part of the process right now when you're just discussing the redevelopment plan. That does not happen until the actual application goes before the planning board.
Okay. Thank you for that clarification. Let's go. Isabella, you're next in line here.
Joe, just to add to what you said, the problem in Northfield, what's going on in Northfield, and it's probably going to happen much more in downtown West Orange and Main Street, it's not just traffic. I wish it was just traffic. I live in Northfield Avenue, and it's much, much more than that. It's environmental, and it's huge. The impact of pollution in Northfield Avenue have increased by day, and it's clear in my house. I can see it, I can feel it, I can sense it. Next, the impact on the South Mountain, like, I don't know if you guys saw what happened during the storm. Stones were coming down from all over the reservation through Northfield Avenue. My husband got home during the storm, and he had like flat tire from big, huge pieces of rock that were coming down there. More water is coming down like crazy. Then all this is just piling up. And on top of that, the Essex County doesn't give us what we need in Northfield Avenue, which is a county road, which is basic stuff like sidewalks. As you guys all know, it's the opposite. They put signs on corner of Northfield and Pleasant Valley now that says that pedestrians cannot cross that anymore. I don't know if any of you saw that already. We cannot cross Northfield anymore. Only one little place. All the other crossings, Northfield and Pleasant Valley Way, you cannot cross anymore. Like if you're coming down from anywhere where I live or the reservation, you cannot cross Northfield and Pleasant Valley Way in any point on that corner, the four corners. Then it's much more than just the traffic. And I can tell you guys, because I live here, I know exactly what's going on, and it's upsetting to see. And I don't know if you guys saw on Facebook what happened with the property at 275 Northfield Avenue, where the landslide came down behind the property building. That is probably what we're going to happen if they build anything on Northfield at the Essex House, because I don't know if you guys heard what happened, like amount of water that was coming down that hill too. And also that's what I want to do with the box at Pleasant Valley Way, where the planning board authorized them to get inside the
CubeSmart.
Right?
CubeSmart, yes.
Yeah, the CubeSmart. It's all the same stuff. This town is not thinking on environmental impacts of anything they are doing. And it's sad because with climate change, a storm like Ida, we just keep getting bigger, faster, more frequent, and it's not a way back. If they don't stop this now, how this town is going to be in 5 years? I'm not talking about 10, I'm talking about 5, because it's coming fast. Like the amount of water that was in all the houses. This is all consequences of the same thing. It's development without thinking what you're doing. Like all the houses on St. Cloud's, everybody got flooded. in their business because of the little creek that comes to the Orange Reservation that is not even taken care of either. And all the houses got flooded. Why? Like they are not looking environmental impacts before building anything. And I asked this question during not one, but many meetings of during the box thing, because I call the box, because that's all it is, that build and plaza evaluate. And the planning board said, oh, we are not required to do the environmental impacts. I'm like, what you guys are thinking? Like, I cannot understand that, where we are going with this. The only explanation, sorry to say, but the only explanation might exist is corruption. Something is going on in this town. You can't, like, I don't think I have another explanation anymore, because they are destroying West Orange in front of us. I think it's pretty simple.
Thank you, Isabella. Let's see, let me go right to Kevin.
Thank you, Laura. First a comment and then a question. When PRISM was being proposed as the developer, Eugene Diaz, the principal of PRISM, bragged that PRISM had $675 million in financing available to it. I and other members of the
Today
public
was the
demanded to
13th,
see the
and
financial statements of PRISM.
Friday is the 17th. I could do this Friday.
Rosary, can you just mute yourself?
Okay.
All right. Talk to you later.
Okay. Take care. Bye.
All right. Bye-bye.
Kevin, let me, okay, go ahead, Kev.
So when it's been asked what we as members of the public can do, we can demand greater transparency. We can again demand to see the financial statements and creditworthiness of the developer. So we are not stuck in a situation where a developer has been picked and they can't proceed with the project because they don't have any money. Then a question for Joe. Joe, in your experience on the council, have you ever seen a property or properties purchased where the individual lot is not indicated in terms of the value for which it will be acquired? Thank you.
No, you make a very good point. I understood that the township cannot buy property unless it has at least one appraisal. So it sounds like what the mayor wants to do is push through the borrowing authorization, and then at some point push the button to actually borrow the funds when he gets around sometime between now and the end of the year. I mean, it's just crazy. But as you know, when a municipality borrows money, when it borrows, like say $13 million, it actually borrows a little bit more than that to cover the interest that would be due that in that calendar year. Because so you actually aren't paying interest out of the town treasury until the following year. So it doesn't actually hit the books in the same year that it's done. So, for example, what would happen is we might authorize this transaction of $13 million. It goes on our books as $13 million issued and authorized because it's authorized, but then there's no requirement that anything else happen except the CFO calls up a bank and says, do you want to buy $13 million of our bonds? It doesn't have to go back to the council or to the mayor to do anything else. But yeah, I don't think we can actually buy property without an appraisal, and in some cases requires two appraisals.
Thank you, Kevin. Thanks, Joe. Okay, Claire.
Yeah, Joe. So I have a few questions based on that. I know that I've always been asking about the affordable housing, and the town's going to be on the hook. Whoever comes in after this has got to pick up the phase one. But even even if it's a movie studio, am I right that there's still affordable housing would be attached to even a commercial property? Is that true?
Absolutely correct. Any sort of substantive development triggers an affordable housing obligation.
And somebody asked in the chat about, why doesn't, if Whoopi Goldberg Productions wants to build a movie studio, why don't they just purchase the property directly from PRISM? Why,
Well,
why wouldn't that make more sense that they just go, that the town approves them for the movie studio and then they go and purchase the property from PRISM and negotiate with them? Why is it that the town feels the need to purchase the property? And then, the expectation is, I guess, that then the town will sell it to Whoopi Goldberg Productions. So what's the benefit? What's the up and the downside of doing it that way?
Well, the potential benefit would be that you can entice a new redeveloper by saying, we have the property, we will sell it to you. You don't have to go through the process of trying to negotiate to acquire the property or go through what's oftentimes a lengthy eminent domain process. So it would potentially speed up the process of finding the new redeveloper. But you've got to remember, we just fired the old redeveloper. We haven't even, as far as I know, got a new redeveloper, and that's going to take weeks, if not months, to secure. So I wish I had a better answer for you, but I don't understand why PRISM was supposedly negotiating with Whoopi and MBS to sell them that property. If you noticed, the litigation says that they were actually negotiating to sell part of the commercial space in phase one, not to lease it, to sell it. So I don't really know why that would be, because again, the designated redeveloper has exclusive rights to redevelop. Sounds like what they would do is sell it to MBS and Whoopi, and then go through the process of designating them as the redeveloper for that particular property. With
right, and one other thing that what I've seen and what I've read is it doesn't appear that Whoopi and MBS are residential developers. So this whole idea of putting in all this residential housing, perhaps, is it possible to have two developers in a project?
Yeah, but you wouldn't necessarily have two developers for a particular piece of property. Maybe it'd be a joint venture, or that's what I was saying. It didn't make sense to me that they were negotiating, according to PRISM, they were negotiating to sell the property to MBS Whoopi. And it appears from the maps that what they were proposing was to sell them the Barton Press property and contiguous parcels to that. But it also
and last question,
if I could just, it also makes sense that if you're doing a specialized development like a movie studio, that you have somebody who has expertise in that area. And conversely, you were pointing out Whoopi and MBS don't have residential experience. Certainly, PRISM did not have movie studio experience. So it sort of makes sense from a functional perspective, but don't really understand how that might happen under redevelopment law.
one last question. At the last council meeting, I think the council approved on second and final reading to make the designation that the entire township is an area in need of rehabilitation. And I wondered if that would have any impact on this whole deal of purchasing the property from PRISM and whatnot.
See, I don't know. I would have to defer to somebody like Kevin who knows that issue a lot better. I spent 15 years with the redevelopment law, and just so everybody knows, it's actually part of the same law. you have both redevelopment and rehabilitation. But I've never focused on it because up until a couple of years ago, we had plenty on the plate just for redevelopment. But, you know, if Kevin or somebody else knows that answer.
Yeah, but I guess though, yeah, I'm thinking of this. I guess it wouldn't matter because once you're in the redevelopment zone, there, you know, like all bets are off, and the town could, Kevin, I guess, it doesn't matter whether it's in rehabilitation or not. They could give they could sell the property without taking bids, right? Because
Exactly right. Yeah, it's the same remedies exist for redevelopment or rehabilitation, except for eminent domain.
Okay, thanks.
Okay, I'm gonna go, let's see, we have another question. I'm thinking that Whoopi can build the studio and make a movie about all the antics that go on downtown. How about that? Be a blockbuster. All right, so Darren has a question. Let's see, Darren, I'll read it here. Does the announced settlement also settle the suit against Whoopi Inc., or does Whoopi Company have to settle it separately?
The mayor says in his text post on his Facebook page that it does cover the other defendants.
Okay. And, oh, great. Thanks, Robin, for the good news. She's saying because a result of the CubeSmart application that was before the zoning board, there's now another storage unit application because they had so much success. Another storage application currently before the zoning board on the property of Eagle Rock Avenue where the bowling alley was located. So if you know that where the Exxon station is, and behind there, another storage unit. Good. Let's see, Sally, why isn't Whoopi paying for Henry Wayman's legal fees? That was the question, Joe. Why isn't Whoopi paying for Henry Wayman's legal fees?
That's a really good question. You know, the converse of that is that why is the town proposing to pay for his legal expenses? I mean, they're really accusing him of violating the NDA, and I don't see how the fact that he's a volunteer chair of the West Orange Economic Development Commission plays any role in that. There certainly wouldn't have been a conflict of interest if he wasn't representing Whoopi Inc. and MBS Holdings in those negotiations. I'm sure if you look at the NDA, he did not identify himself as chair of the West Orange Economic Development Commission.
Mm-hmm.
Hey, Joe, could you just, I know you covered it in your presentation, but just underscore to all of the people on the call that, you know, back in 2011, 2013, PRISM not only wasn't paying their property taxes, they weren't paying their mortgages on the Barton Press building. And that was why the Barton Press building went into foreclosure with Wells Fargo, because they weren't even paying their mortgage. And what happened there was that no one else, it went to auction, right? But nobody else bid on it because, of course, it was in the redevelopment zone. Who could, you know, I'm sure a lot of people looked at it and said, what can I do with that property? And so they got it back for a fraction of what they paid for it. And that was the mortgage they started paying again from 2000, early, I think January of 2013. So when PRISM is talking about the fact that, oh, they're owed so much money, how much money they put into the building, into all their properties, people should be aware of the fact that PRISM not only wasn't paying their property taxes back then in the early 2000s, but they weren't even paying their mortgage. And they did, in fact, lose a CVS property. Then somebody, when that one went into foreclosure, somebody else came in and picked it up. But that Barton Press property is not, they did not pay $13 million. Or they, you know what I'm saying? They're not paying a mortgage on $11 million or whatever it is.
Yeah, and one corollary to that is that may explain why they could never secure a construction financing. Construction financing is the highest risk, just about the highest risk financing you can get from a financial institution. And can you imagine sitting on the underwriting committee and this application comes and they're not only going through one, but two foreclosure processes in the redevelopment area in the same town where they want to borrow $70 million. I mean, how can you expect a financial institution say, here, even though you're going through two different foreclosures, we'll give you $70 million. I just laugh at what the underwriting committee meeting must have been like. You know,
So
it's
Joe,
like you going in to get a mortgage on a home while you're going through not one but two foreclosures on your previous properties, your other properties. It's just,
I'm hoping you can help me get my head around it, because I'm trying to, in my little black and white thinking, I'm trying to put boxes around things that are very all over the place. And, it seems to me like there's really no good guy. PRISM's not the good guy. The township's not the good guy. The taxpayers are going to end up paying the brunt of all this, what's going on downtown and with the lawsuit. So what's the outcome that's beneficial to us? Us little minions here in town.
well, I've been saying this for years. Come to the council meetings and let your voice be heard. I know that's simple, a simple solution. It may not work, but certainly I don't think we put enough pressure on the council members and the mayor, our elected officials, to be more responsive to what we're looking for. But you're right. Somebody posted on Facebook about the Bank of Us, that this settlement is potentially coming off the backs of taxpayers, just like redevelopment is. And the issue is that I think not enough people understand to the degree they need to how we can be potentially patsies for all of the stuff that happens behind closed doors and behind the curtain. And as soon as that curtain is lifted, like what we see in the lawsuit, we say they would never have been doing this if they had to come to the council every 2 weeks and disclose this stuff. Right? I mean, it's almost too much to believe that all of this stuff was going on, and it looks like they weren't even telling the council about what was going on. And the mayor's been elected and reelected as mayor twice, and he was elected and reelected, same thing as council person. So I guess we can forgive him for thinking that he doesn't have to pay attention to us. He keeps getting elected, and I can't.
Hey, Joe, I think what Lauren is asking, though, is if we're going to advocate for what's in the best interest of the township, because we seem to, it appears to be that our town government is not working in the best, the deals that they're making, the actions that they're taking are not necessarily in the best interest of the residents, the taxpayers. So what should we be advocating for? What is at this point? I mean, they've totally screwed this up royally, but to get ourselves out of it, what's the best way to go?
I see. Okay. So my answer is always going to be transparency and accountability. You got to hold our elected officials accountable, and the way to do that is to get as much transparency as possible. In this case, we should all be demanding transparency. We should be demanding competitive process. Open this up to as many developers as want to come in and pitch us, and see what we get, see what the market will bear, and the more transparency that's there, the more accountability that will be there, and the more likely that our elected officials will listen to us. But I think this whole thing of not going with competition and not providing any transparency just has to stop. We've seen the results of what happens when that's not done.
Okay, there was one, thank you very much, Joe and Claire, for clarifying my unclarifiable question. Let's see. One question that I overlooked here. Has Mr. Trenk, our township attorney, benefited from the settlement beyond his typical salary as the township attorney?
So the way the contract is constructed with the town attorney and the assistant town attorney is that they're paid a salary of, I don't know exactly what the number is. I think for Mr. Trenk, who's the town attorney, I think it's $42,500. And he and his law firm for that money handle all of the routine legal stuff that happens. But as soon as there is litigation that they are going to be involved with, they immediately switch to a per hour cost. And I think the fixed amount, if I remember correctly from the last contract, is $175 an hour. So litigation, they can, when there's instances of litigation, they can quickly run up the tab. But typical, just reviewing, ordinances and developing ordinances and resolutions, that stuff is all covered in their salary.
Thank you. Okay, 8:30, we've been on for an hour and a half. I want to give everybody an opportunity to be able to ask questions and get clarification. This recording will be made available. Some people have asked me in a private chat if they could see it before tomorrow's meeting. I imagine so they can take some notes and get their thoughts down because there's a lot of information.